Many of you already know about the IRS whistleblower program. Essentially, if there's a violation and somebody reports the violation of tax law to the IRS, that person, that whistleblower, is protected from retaliation. But until recently, the same protections have not been afforded to folks when it comes to dealing with nonprofit entities. Well, that recently changed with the Taxpayer First Act of 2019 that affords very robust remedies to combat retaliation. How does it work? What's it all about? We're going to cover it right here. You're going to want to stay right where you are. Welcome, fellow tax nerds, geeks, and other aficionados to Deep in the Heart of Taxes, the only show that takes the time to boil down all of the tax law news that's fit to share, and some of it that isn't. All so that you don't have to. As always, you're going to find the links to the full stories in the description below. I'm your host, Jack Manhire. The following is from an article by Jason Zuckerman and Catherine Krems from the Zuckerman Law Whistleblower Protection Law blog. Tuesday, July 21st, 2020. Headline, Whistleblower Protections for Nonprofit Employees. The tax code affords major benefits to nonprofits, including exemption from the corporate income tax and the deductibility of charitable donations, which approximately 37 million taxpayers avail themselves of annually. These advantages, combined with limited liability provided by state corporations law and eligibility for grants, have led to a significant expansion of the nonprofit sector. More than 1.56 million nonprofits are registered with the Internal Revenue Service, and the nonprofit sector comprises approximately 5% of the U.S. GDP. The nonprofit sector employs over 12 million workers, and revenue for registered nonprofits amounts to $2.54 trillion with a T in 2015. In addition, nonprofits receive more than 30% of their overall revenue from government grants and contracts, amounting to over $750 billion every year. To maintain tax-exempt status, nonprofits must not run afoul of the IRS rules, including the following prohibitions. 1. Using a nonprofit to influence the outcome of any public election. 2. Operating a nonprofit for commercial purposes or to benefit private interests. 3. Misusing grant funds to provide excessive compensation or benefits to nonprofit executives. 4. Generating income for purposes unrelated to the organization's main charitable purpose. And 5. Spending a substantial amount of time or resources on lobbying for or against legislation. Until recently, federal law provided minimal protection to whistleblowers at nonprofits who suffer retaliation for reporting violations of the requirements for maintaining tax-exempt status. But with the enactment of the whistleblower protection provision of the Taxpayer First Act in 2019, Congress provided whistleblowers at nonprofits with a robust remedy to combat retaliation. In particular, Section 1405B of the Act prohibits any employer or officer, employee, contractor, subcontractor, or agent of an employer from retaliating against a whistleblower for disclosing violations of IRS regulations, including regulations governing nonprofits. Now, the Taxpayer First Act protects a broad range of disclosures about potential violations of IRS rules or of tax fraud. It protects not only disclosures to the IRS, but also internal disclosures, including an employee's disclosure to a supervisor or, quote, any other person working for the employer who has the authority to investigate, discover, or terminate misconduct, end quote. In particular, the Taxpayer First Act protected conduct, the Taxpayer First Act protected conduct includes providing information to a supervisor regarding underpayment of taxes or any conduct that the employee reasonably believes constitutes a violation of the Internal Revenue laws or any provision of federal law relating to tax fraud. Participating in an internal investigation about tax fraud or other violations of Internal Revenue laws. Reporting tax fraud or other violations of Internal Revenue laws to the IRS, the Comptroller General, Congress, the Treasury Secretary, or TIGTA. Or testifying, participating in, or otherwise assisting in any IRS administrative or judicial action relating to an alleged underpayment of taxes or any violation of the Internal Revenue laws or any provision of federal law relating to tax fraud. Examples of protected disclosures by nonprofit whistleblowers include reporting 1. An organization spending a substantial amount of its time and resources on lobbying. A nonprofit organization generally should devote 5% or less of its overall activities to lobbying to safely remain within the IRS's prohibition on substantial lobbying. 2, an organization engaging in political activity meant to influence the outcome of any public election. This includes making public statements in support of or in opposition to any candidate for public office, as well as political campaign contributions. 3, an organization not being organized and operated mainly for charitable purposes. A nonprofit organization must mainly engage in charitable tax-exempt activities. And 4, an organization operating to benefit private interests, including for the personal benefit of the creator or the family, shareholders, or other individuals. Now, a Taxpayer First Act whistleblower can prevail by showing that they engaged in protected whistleblowing. They were subjected to a retaliatory adverse action, and the whistleblowing was a contributing factor to the employer's decision to take the adverse action. The Taxpayer First Act prohibits a wide range of retaliatory acts, including discharging, demoting, suspending, threatening, harassing, or in any other matter discriminating against a whistleblower in the terms and conditions of the employment. The catch-all category of retaliation, in any other matter discriminating against a whistleblower, includes non-tangible employment actions such as outing a whistleblower in a manner that forces the whistleblower to suffer alienation and isolation from work colleagues. An employment action can constitute actionable retaliation if it would deter a reasonable employee from engaging in protected activity. A contributing factor causation standard is favorable for whistleblowers. It merely requires a showing that protected activity only played some role, and even an insignificant or insubstantial role may suffice. Examples of circumstantial evidence that can establish a contributing factor include temporal proximity, the falsity of an employer's explanation for the adverse action taken, inconsistent application of an employer's policies, an employer's shifting explanations of its actions, animus or antagonism toward the whistleblower's protected activity, and a change in the employer's attitude toward the whistleblower after they engage in protected activity. Once the whistleblower proves that their protected conduct was a contributing factor in the adverse action, the employer can avoid liability only if it proves by clear and convincing evidence that it would have taken the same adverse action in the absence of the whistleblower engaging in the protected conduct. A prevailing whistleblower under this act is entitled to make-whole relief. Now, make-whole relief includes reinstatement, double back pay with interest, uncapped special damages, which courts have construed as encompassing damages for emotional distress and reputational harm. And another make-whole relief is attorney's fees, litigation costs, and expert witness fees. Now, the whistleblower retaliation under this act, any claims under this act are filed initially with the U.S. Department of Labor, okay? The Labor Department. The statute of limitations for a Taxpayer First Act whistleblower retaliation claim is 180 days from the date that the employee is first informed of the adverse action. If OSHA determines there is reasonable cause to believe a violation occurred, OSHA can order relief, including reinstatement of the whistleblower. Either party can appeal OSHA's determination by requesting a de novo hearing before the Department of Labor's Office of Administrative Law Judges. But an employer's objection to an order of preliminary relief may not stay the order of reinstatement. Once a Taxpayer First Act retaliation claim has been pending before the Labor Department for more than 180 days, the whistleblower can remove the claim to federal court and try the case before a jury. Now, the whistleblower protection provision in the Taxpayer First Act provides robust protection for whistleblowers at nonprofits, which ultimately benefits nonprofits, their donors, and the general public. Jason Zuckerman and Catherine Krems conclude their article by stating that by encouraging employees to report potential violations, nonprofit management will benefit from early detection of both fraud and other tax violations and have an opportunity to rectify those violations. There you go. That's the blog from Jason Zuckerman and Catherine Krems at Zuckerman Law. So what do you think about this? What do you think about the new protections? The new protections seem like they are regular retaliatory remedies. Some of them are a little bit more beefed up as far as what a whistleblower can receive if they can prove their case and that the employer cannot prove the case against it. But what do you think? A lot of you listening, I know, work in tax law. I know a lot of you have worked with regular whistleblower claims. How do these provisions stack up against the other whistleblower claims? All right, that's our show for today. If you liked it, please hit the like button and hit the share button. Share it with your friends, your family, get everybody all over here. We'll have a party, okay? And then also, if you would, just very, very, very gently obliterate that subscribe button and that bell icon to turn on the all notifications. That way, you'll make sure that you know when our next show drops, and when it's a premiere show, you get to be involved in the live chats. Thanks for listening to Deep in the Heart of Taxes. This is Jack Manhire, wishing you many happy returns.